It's time for another edition of Lewis at Large with Warner Lewis. 60 minutes of smart talk radio with interesting guests from all walks of life begins right now. So sit back and enjoy. And now, from the flight deck, here's your host, Warner Lewis.
Well, welcome everybody to another edition of Lewis at Large. Yours truly, Warner Lewis from the flight deck, and of course some smart talk radio is in your future, and this segment no exception. An interesting one, this segment indeed. It's called Black Mondays, a brand new work by Joel D. Joseph, The Worst Decisions of the Supreme Court. There's also a foreword by Justice Thurgood Marshall. Joel Joseph has written many books, most of them about the law. He's a graduate of Georgetown, also earned an economics degree at Northwestern University. Presented many cases to the Supreme Court, representing, quite frankly, a wide variety of clients. Also served as publisher at the National Press Books for 10 years. He is the chairman as well of Made in the USA Foundation. We will explore these and many other subjects of interest with Joel. Joel, how are you, my friend?
I'm doing well. How about yourself?
Well, you're busy, aren't you?
I'm pretty busy.
You're pretty busy. Let's do this. You have practiced and presented to the Supreme Court. The work is called Black Mondays: Worst Decisions of the Supreme Court. Give us a little bit of background about why this subject. Obviously, we know why it would be of interest to you, but what do we need to know here, and what really motivated you to put this together?
Well, actually, this is the fourth edition of the book. The first edition was written in 1987, quite a while ago. And my initial interest was more academic. I follow the Supreme Court closely, and a lot of the cases are historic cases like Dred Scott case, which, most commentators believe led to the Civil War. And then more recently on this update, the Supreme Court has really reinvented itself, so to speak, and I think there's been a power vacuum in Washington, D.C., and the Supreme Court has filled it. For example, in campaign finance reform, the Supreme Court has jumped in and really expanded its authority in the Citizens United case, for example, and I can go into details about that, but basically taking the limits off of campaign contributions and really opening a whole Pandora's box on the campaign scene. They have also, even though the court and most of the members of the court, including Chief Justice Roberts, testified before the Senate during their confirmations that they would stay with precedents, that they wouldn't reinvent the law and create law and become activist judges, although they've become a real conservative activist court. They've done it on gun control, basically throwing out gun control laws across the country from Washington, D.C. to Chicago, Illinois. And as you know, Chicago's in the midst of a real curse of violence, gun violence in that city, and the city's been trying to control violence from gangs and so forth, and the Supreme Court puts a roadblock in their way.
Joel, let me ask you something. You touched on the phrase activist as activist court. Is it reasonable to assume from time to time the word activist court is used in a negative light if you are a conservative and the court is deemed liberal, and hence vice versa if you're liberal and the court's deemed conservative? And if that's the case, is therefore the Supreme Court in essence at most times considered an activist court by somebody?
Well, for many, many years it wasn't an activist court at all. It certainly became an activist liberal court during the Earl Warren term of office, and there were that raised a lot of uproar. That's when the court was more liberal than it is today, and now it's become an activist conservative court in my mind. And, of course, you'll get objections from both sides, but this court and the conservatives have always objected to the liberal activists and said, no, we won't be activists, but certainly they are, and The one that I think is the worst decision they've had in the last probably 100 years is Bush versus Gore, which was clearly decided on purely political grounds that
right.
installed George W. Bush as President of the United States. And I've had the honor to communicate with Justice O'Connor, who retired from the court, and she believes, and she was in the majority at that time, that it was a mistake to get involved in that case. That, I think, has tainted the court, and the court should have just stayed out of that and let Florida decide who won the electoral votes in Florida.
Joel, kind of again with the political wins, can you make the case for a court that sort of swings left, swings right, swings to the middle in many ways that the political winds do up on Capitol Hill and in the White House? Is there some value to that? Well,
first of all, the court's always been political. There's no doubt about that. I think the best court would be one that was trying to stay above the political fray. And I don't think we've had a court like that in quite some time. It is difficult because they are political appointees. I think justices should be chosen to be, the best and the brightest, and those with a good sense of justice. And I'll give two good examples, and I think actually they were both Republican appointees. It turned out to be very good justices. Justice John Paul Stevens was appointed by President Ford, and I'm sure it's much to President Ford's regret, he became more of a liberal. But I think he has a true sense of justice, as does Sandra Day O'Connor, who was appointed the first female justice appointed by Ronald Reagan. And I think those two have been great justices, and, their dissents ring throughout this book. And give a couple examples if you like.
Please do.
One that I think defies liberal and conservative labels is the case of Kelo versus the city of New London, Connecticut. I'm not sure if you're familiar with that case, but the town of New London wanted to develop the seaside area. It's on the Atlantic coast, and they decided to use the power of the states, a power of eminent domain, to take property from people, personal homes that their families have owned for many years, including Ms. Kelo, who lived in this house, I think, for 50 years, and use it for private development. It was going to be a Pfizer plant, the drug company. And the Supreme Court allowed the taking and caused a huge uproar, mainly from conservatives, even though the court was basically conservative. And there were all kinds of repercussions. In New Hampshire, where Justice Souter is from, the state legislature tried to take his home and create use the power of eminent domain to take his home. That never happened, but there was quite a revolt in this country. There still is. Many of the states are trying to tighten up on the right of a state to take personal property. I believe that the case was wrongly decided because, of course, a state can take property for a public purpose, as the Fifth Amendment allows, but I don't believe it has the right to do so for private development.
Joel, and again, if you just joined us, yours truly, Warner Lewis from the flight deck of Lewis at Large Radio. We're talking to Joel Joseph, who has released and updated, I guess, the fourth edition of Black Mondays, the worst decisions of the Supreme Court. Mr. Joseph has spent much time in front of the Supreme Court, has practiced law and written on the law for many, many years. Joel, is there, as you look through the work here and the worst decisions as you deem them, whether it's an activist, conservative court, liberal court, etc., what do these things have in common? And maybe at an even higher level, is there a legal, social, or political environment that is common or that creates sort of this petri dish for these kind of decisions to happen?
All the decisions are separate, really. I do think that the court gets sometimes too deeply involved into precedent of individual lines of cases and doesn't see the forest through the trees. Let's see if I can give you a good example on that. There was a case involving the Postal Service that a citizens association was handing out leaflets door to door, and they stuck them in the mailboxes often. And they were actually prosecuted because there's a federal statute that prohibits people from handing out flyers into mailboxes without putting postage on them. And, the court went straight through the cases on the power of the post office, et cetera, but I think missed the whole point that this is a First Amendment right, and this is the only way you can contact some people in some areas. So I think that might have been the only case while he was alive, and Justice Thurgood Marshall wrote the foreword to the book. I think that might be the only opinion that he disagreed with me on in the entire book. And I think that the First Amendment, I believe, should trump the right of the post office to require people to put postage on their mail that's stuck in somebody's mailbox where a postman never did anything. I'm not sure if we can give a clear picture of how all these cases come about, but as I said, sometimes they don't see the forest through the trees.
Right. What about, again, is there, and again, as you said, these are all separate, but the Supreme Court has handed down thousands and thousands of decisions. How did you come up with the worst ones? What kind of sort of criteria? Were there ones that immediately came to mind to you? And if we had other legal scholars in the room, would it be a big knockdown, drag-out brawl as to, no, that wasn't the worst, that was one of the best, et cetera, et cetera? What, is there any kind of a...
Of course, not everybody would agree on them, but I did consult with many different organizations and law professors, and, this was developed, I hate to say this, but I've been practicing law for over 40 years, so it's, looking at the court over a 40-year period and really over its 230-year history. Now, most would agree, for example, that the Korematsu decision, where we interned Japanese-American citizens during World War II, even though they were born in the United States solely because of their country of origin, most commentators, I'd say 99%, would agree that was one of the worst decisions. Now, some of the more recent cases, there'll be some more controversy. So it depends on the historical context. Another one that's in the book that nobody's ever heard of is it's called Minor versus Saperset. And that was where the Supreme Court said women didn't have the right to vote. And if you look at the Constitution, male and female is never mentioned, only persons and citizens and so forth. And the Supreme Court just said, of course women don't have the right to vote. 9-0. It's the only unanimous case in the entire book. And that was decided after the Civil War when African Americans could vote. African American males got the right to vote before white females, which is surprising to a lot of people. But so in historical context, I think almost everybody would agree that women have the right to vote and that the Supreme Court was wrong on that. The more recent decisions that I pick on, I'll give you one that is offensive to me, and if you look at it in the context of the number of shootings, mass shootings by young males in the past couple of years, it puts it into context. The state of California passed a law that said violent video games could not be sold to minors. Parents could buy them, but if you were under 18, you couldn't buy a violent video game. And the Supreme Court, I think, went way off on this one. And it was, again, a 5-4 decision, which I really find offensive, because if you can't get more than a 5-4 majority, there's something wrong, that the law is obviously not clear. Justice Scalia in that case said Of course, violent video games have no connection to violence. But if we look at the recent occurrence in my state of California, in Santa Barbara, the 22-year-old shooter was an active violent video game participant, as was Mr. Lanza in Newtown, Connecticut. There's a real pattern that a lot of these 20-some-year-old males who have been isolated from society are playing these violent video games and then go out and have mass shootings. So I think there's definitely a connection. The Supreme Court, and a conservative Supreme Court that believes in states' rights, shouldn't overturn the California law.
Let me, in general, go back a decade. There's appointments to the Supreme Court. In general, conservative, liberal, moderate. Do you think overall the crop of appointees have been good, or have we made some fundamental wrong decisions in our choices of justices?
Well, I think the justices on the court right now are mediocre across the board, liberals and conservatives. And I've met about half the court, and I'm not impressed with the conservatives or the liberals. I think there are better conservative constitutional law professors who could have more reasoned decisions, and there are better liberal professors and other judges. And I'm disappointed in the quality of the judges, and the overriding factor in what makes a bad decision, I think, are bad judges.
What about, okay, again, act as historian here. There have been Republican presidents. There have been Democratic presidents. Why are the appointees, in your opinion, of lesser quality than they have been throughout history?
Well, it seems to be that we didn't used to pick Supreme Court justices based purely on politics, and we are now. Justice Eisenhower, for example, President Eisenhower, for example, he lived to regret it, but he picked two justices that turned out to be very good justices, and they weren't as conservative as he would have wanted, but he picked the best legal minds he could, and he did say that they were the two biggest mistakes of his administration. And one of those was Justice Brennan, who was a Republican, but like Justice Stevens, became more liberal as he stayed on the court. So back in the 50s, you didn't have a litmus test, and abortion wasn't really an issue in 1952 or 54. And now we have almost, incredible litmus tests on both sides of the aisle. So the best and the brightest are not being selected as they were, I think, 40, 50, 60 years ago.
What would this is a little bit of a fantasy game here, but Joel, Thomas Jefferson is alive today, reviews the decisions of the court of the last quarter century. Is he shaking his head in disgust? What's he thinking?
Well, Thomas Jefferson's one of my heroes, actually, and I think he'd be very disappointed in the court in many ways. Of course, I think it's true with a lot of, he was definitely a Renaissance man in many ways. Jefferson was, he was an inventor and a writer, and he worked on the Declaration of Human Rights and religious freedom and so forth. He'd be very disappointed in the court. And I think in a lot of the things that are going on in the nation, I think the thing he'd really be upset about is the spying on domestic citizens by the National Security Administration. I think that would shock most of the founding fathers.
Well, the work is called Black Mondays, edition number 4, the worst decisions of the Supreme Court, with a foreword by Justice Thurgood Marshall, written by Joel Joseph, long recognized as one of America's legal scholars, numerous books about the law, about the court. He has practiced in front of the Supreme Court. Joel, is there one, again, with all these different, they're all different, they all have their own unique qualities and non-qualities. Is there any kind of high-level sort of takeaway here? What are we learning from this book? What's the takeaway here?
Well, the takeaway is that the Supreme Court is one of the most powerful branches of government. And when we have a Congress that doesn't seem to be able to order a pizza, the Supreme Court will step into that vacuum and make decisions because it has to make decisions. And if Congress doesn't give it the guidance that it needs, it will rule on the cases before it. And sometimes it'll ask Congress to make a decision, which I don't think we've had a worse. I don't think we've had a worse Congress in the history of the United States. We've certainly had. This has been the least productive Congress in terms of legislation that have been passed in 200 years.
Again, Black Mondays is the name of the work. Joel, how can people get a copy of this and also find out? You've got a lot of writing out there, a lot of things, a lot of material out there. How can they find out more?
Okay, they can order the book from Amazon.com, or it's available at the iTunes store or any local bookstore.
And do you have a website?
Well, I don't have a personal website. As you mentioned earlier, I'm chairman of Made in the USA Foundation, which...
Yeah, excuse me. You know what? I did want to touch on that. Tell us about that before we head out of here.
Well, I started the Made in the USA Foundation 25 years ago to promote American products and basically help create jobs in the United States. And it's been fairly successful. We've had a couple pieces of legislation passed. Most recently, the Country of Origin Labeling Act, that I know I've got a lot of big supporters in Kansas. It requires country of origin labeling on meat, chicken, vegetables, and so forth. And a lot of the Cattlemen Association in your neck of the woods are big supporters of that legislation, and which has been challenged overseas. A lot of litigation has been involved in it. Mexico and Canada have challenged our Country of Origin Labeling Act because they think it discriminates against Mexico, which it does, but we want to inform consumers where their meat and produce comes from.
Well, listen, thank you so much for spending time with us, and would like to have you on again sometime.
Love to be on again. Thanks for having me.
You bet. We will be back with more right after this on Lewis at Large.